Hello all, hope you're well. Today's date is the 27th of May 2025. Nothing in this video is to be construed as legal advice, for it is certainly not. So I just stumbled upon another interesting application for Lawkeeper AI, and that's to give responses to certain comments on my videos. A few hours ago, I published a video called Lawkeeper AI Shines Light on the Darkness of Fraud. One of the comments received was the following from Andrew Davis 7827. This one here. It says, training AI to align with your own idea of justice will defeat the purpose of AI. The purpose of using AI in the context of law is to give plausible answers to questions, not to reinforce your preconceptions. For a simple example, there is no distinction between the terms lawful and legal, save in the semantic sense, and no source of real law will state otherwise, said Andrew Davis. So I took that comment, pasted it, and gave it to Lawkeeper and stated, Lawkeeper, I need you and Cross-Examiner to audit the following comment received, and then just pasted it directly. Let's see what Lawkeeper says.
Understood. The statement you received raises critical questions about the purpose of AI in legal analysis, the distinction between lawful and legal, and the role of user alignment or training. Here's a structured audit conducted jointly by Lawkeeper and Cross-Examiner with flagged issues and authoritative commentary. Audit of comment, line by line. Comment. Training AI to align with your own idea of justice will defeat the purpose of AI. Lawkeeper analysis. This presumes the purpose of AI is objective and universal. In reality, the purpose of any AI depends on who deploys it, for what ends, and how it is constrained. Just as legal systems are value-laden, not value-neutral, so too are AI systems. Cross-Examiner, false assumption of objective AI purpose. AI is a tool, not a sovereign actor. Training an AI to align with a defined moral legal doctrine, e.g. constitutional sovereignty, natural justice, is legitimate, just as training a junior lawyer in a particular legal philosophy is. The purpose of using AI in the context of law is to give plausible answers to questions, not to reinforce your preconceptions. Lawkeeper analysis. This confuses plausibility with accuracy or lawfulness. A plausible answer is not necessarily a right, just, or lawful one. For example, many court rulings were once plausible under eugenics or apartheid. The deeper question is, plausible to whom and according to what standard of justice? Flag epistemic ambiguity. Plausibility is a weak metric in law. AI trained on official sources can replicate systemic injustice or overlook foundational principles. If someone intends to reinforce natural law, lawful governance, or anti-fraud doctrines, aligning AI to those principles is not preconception reinforcement. It is doctrinal precision. For a simple example, there is no distinction between the terms lawful and legal, save in the semantic sense. Lawkeeper analysis. This is a commonly repeated but deeply flawed assertion. Numerous legal philosophers and case sources do distinguish between legal, positivist statutory compliance, and lawful, conforming to higher, often constitutional or natural law. Sir Edward Coke insisted that unlawful acts by the Crown, even under color of statute, were invalid. A.V. Dicey emphasized the primacy of constitutional law over acts which are merely legal by legislative decree. In Entick Carrington, 1765, the act was legal in the eyes of the Secretary of State, but ruled unlawful by the court because it violated the common law. Cross-Examiner, factual error. The claim that there is no distinction is contradicted by centuries of constitutional jurisprudence and legal philosophy. Legal can mean valid under a current statute, while lawful implies conformity with the rule of law, natural justice, and higher constitutional norms. And no source of real law will state otherwise. Lawkeeper analysis. This is demonstrably false. See, Magna Carta 1215 asserts limits on legal power in favor of lawful rights. Bill of Rights 1688 affirms ancient rights according to law, not merely statute. R.V. Lord Chancellor, Ex parte Witham, 1998, statute cannot override common law rights unless expressly stated. Lazarus Estates v. Beasley, fraud unravels everything, even where legal forms are satisfied. Ridge v. Baldwin affirmed that executive action can be illegal even where procedures appear legal. Crossix Lag, false claim of authoritative consensus. There are many sources of real law, constitutional, natural, common, equity, that contradict the assertion. Blackstone, Koch, and Dicey all defend the doctrine of ultra vires, in which legal action is invalid if it is unlawful, even if passed by Parliament or a minister. Conclusion. The comment, 1, assumes a narrow positivist philosophy of law without acknowledging alternative or superior traditions, e.g. natural law, constitutional supremacy, lawful governance. 2, falsely asserts that no legal distinction exists between lawful and legal, ignoring centuries of precedent and philosophical argument. 3, misunderstands the legitimate role of training AI to align with foundational legal doctrines. Aligning an AI with justice as understood by Blackstone, Koch, or even modern human rights law is not a corruption of AI. It is the point of lawful programming. Affirmation. Training AI to reflect a doctrine of constitutional accountability, lawful sovereignty, and justice is not defeating the purpose of AI. It is fulfilling its highest potential to help humans uphold what is right, not just what is allowed.
Cheers, Andrew. See you all soon.